Good morning, everyone. I would like to acknowledge the presence of the acting Permanent Secretary, Ms. Celia Christopher. I also like to acknowledge the presence of our Director in the Department of Probation and Child Protection Services, Ms. Marcella Simon. Also, I'd like to recognize Ms. Blake, from the Director of the Counseling Unit, and also Ms. Margaret, as we affectionately call her, of the Children's Home, the Director of the Children's Home. And also members of the board, the Child Welfare Board, who is here this morning also. I'd like to apologize for the absence of the Chair, Mr. Maurice Williams. This morning, I am tasked with a very serious responsibility. It's basically to give a direct overview of what this child protocol have been through throughout the years. Bear with me as I make a valiant attempt at doing such. I hope it does not bore anyone here, but it's a very lengthy overview. It dates back to 1990 when we first signed on to the Convention of the Rights of the Child. So bear with me, please. The problem of child abuse and neglect in all of its forms remains a concern of the entire population of St. Kitts and Nevis. Ongoing advocacy have increased awareness of the incidence and prevalence of the act of maltreatment. Responding to child abuse continues to be a significant challenge for the entire community. While there is overwhelming adherence of these acts of cruelty perpetrated against innocent children, too many abused and neglected children are being missed by a system designed to offer them protection. Recognizing the special needs of child victims, prosecutors, law enforcement officers, child protective services employees, health education professionals, other mandated reporters, and their commitment to working together to address the problem, the gaps in the child protection system constitutes opportunities to rectify the situation and the development of a single child protection mechanism guided by a national child protection protocol. The minimum inputs of a robust system of child protection in the Federation are sound. Best practice procedures performed by competent personnel who in turn are supported with the required material resources. The major obstacles to progress has been the recurring issues of response agencies working at cross purposes. What is required is emphasis on integrated and focused actions directed to meeting the needs of each child while accounting individual agencies' operating procedures. The protocol is believed to be the roadmap for renewed and assertive action. Having a protocol is of no value without leadership will to ensure its full implementation. It is expected that the enabling environment will be created in order for providers to perform at their best in the work in prevention, investigation, management, and reporting of child abuse and neglect. Despite the advances in the regulatory framework, the public agencies responsible for social justice and child protection in St. Kitts and Nevis continue to experience obstacles in discharging the mandate required by law and convention. At a 2006 consultation entitled Advancing Child Protection, Keeping the Promise, hosted by PCPS, all stakeholder agencies arrived at a general consensus that there was disarray among the services, which led to the systematic failure to effectively provide a coordinated national response to the problem of child abuse and neglect. Following the conference, PCPS requested support from UNICEF for the study to be carried out to investigate the status of child protection in St. Kitts and Nevis and to advise on the need for a national reporting protocol. The ministry responsible for child protection expressed gratitude to UNICEF for its ready commitment to support the consultancy that led to the development of the protocol. The contracted consultant, Mrs. Jacqueline Seeley Burke, produced a document, The Status of Child Protection in St. Kitts and Nevis, the Need for a National Protocol, informed by submissions from a wide representation of stakeholders. This document then led to the development of the National Child Protection Protocol, the Protocol, which the Probation and Child Protection Services is pleased to present. Several attempts have been made to advance the child protection agenda in St. Kitts and Nevis. In the early years, child protection was pursued by the Welfare Department of the government ministry responsible for social services. In St. Kitts, private citizens established and supported the custodial institutions, the Children's Home, Fort Lands, Bastille. While Nevis has no formal institution for abuse and abandoned children, the Change Center, formed in the 1990s by Mrs. Saloni James, provided vigorous public advocacy coupled with counseling services. The Nevis Island Administration also has a ministry responsible for child protection. Key events in advance of child rights and protection include 1990, signing of the Convention of the Rights of the Child. 1990 again, ratification of the Convention of the Rights of the Child. 1992, Seminar of Child Abuse. 1994, enactment of probation and child welfare legislation. 1998, training on formal embodiment of a sexual offenses unit within the Royal St. Christopher and Nevis Police Force. 1998, inauguration of the National Foster Care Program. 2006, consultation, advancing child protection, keeping the promise. 2012, consultation for completion of CRC report. 2012 again, creation of Special Victims Unit, child abuse and domestic violence. 2012, review of foster care program. Amendment of Maintenance of Children Act. Amendment to Guardianship, Custody and Access of Children Act. 2013, enactment of Children, Child and Adoption Act. Enactment of Child Justice Act. Repealed the Juvenile Act. Amendment to Status of Children Act. Amendment of the Probation and Child Welfare Act. Other pieces of legislation relevant to the issues of child abuse and neglect. The Offenses Against the Person Act, Chapter 4.21. The Criminal Law Amendment Act, Chapter 4.05. The Small Charges Act, Chapter 4.36. The Federation of St. Kitts and Nevis was among the first countries in the region to sign and ratify the United Nations Convention on the Rights of the Child, the UNCRC. This was done on the 24th of July, 1990. As party to the UNCRC, countries must submit reports to the UN Committee 2 years after ratification and at 5 years interval thereafter. The report must state what steps have been taken to meet obligations under the treaty. Since ratification on July the 24th, 1990, St. Kitts and Nevis has to date submitted only one report. A second report is currently being compiled and which should include steps that are being taken in conformity to Article 19, which speaks specifically to child abuse and neglect, which states, parties to the UNCRC agree to the following. 1, state parties shall take all appropriate legislative, administrative, social, and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, which in the care of parents, legal guardians, or any other person who has the care of the child. Number 2, such protective measures should, as appropriate, include effective procedures for the establishment of social programs to provide necessary support for the children and for those who have care for the child, as well as for other forms of prevention and for identification, reporting, referral, investigation, treatment, and follow-up of instances of child maltreatment, described therefore, and as appropriate for judicial involvement. One such step is the institutionalization of a national child protection protocol, a process which we will engage today. Some progress have also been made since ratification in the developing and implementing domestic legislation, policies, practices, which are also compatible with the spirit and intent of Article 19 of the UNCRC. The primary pieces of legislation that presently incorporate substantive protection provisions are the Probation and Child Welfare Board Act of No. 6, 1994, which provides for the protection of children whose health and welfare are adversely affected and further threatened by the conduct of those responsible for their care and protection. Among the provisions of the Act is mandatory reporting to the protective services. This ensures structures and processes are in place to handle all cases of neglect, abuse, and in an effort to prevent further maltreatment, to protect and enhance the health and welfare of children, and to preserve family life whenever possible. The Child Justice Act of No. 19 of 2013 and the Children Care and Adoption Act No. 20 of 2013, which recognize the sensitivity involved in dealing with child abuse matters, and as such has made provisions for the privacy of the juvenile to be maintained during the trial of certain matters. The Domestic Violence Act of 2014, which seeks to give protection to children, including children who have experienced domestic violence in the contents of the home and who need protection from violence. The law recognizes the fragility of children who are part of these households and speaks specifically to their protection in the area of obtaining injunctions and protection orders. The purpose of this protocol is to provide an effective and efficient framework to protect children who are likely to be victims of abuse and neglect. It provides the minimum standards for prevention, investigation, reporting, judicial intervention, care, treatment, and support of each child of child abuse and neglect, guided by the provision of the superintending legislation, the Probation and Child Welfare Board Act 1994, revised edition 2002. The provisions also enshrined in the Children Care and Adoption Act 2013 also make the establishment and implementation of a national and well-coordinated response to child abuse in St. Kitts and Nevis, as contemplated by the protocol, as important imperative. This act places legal obligation on relevant agencies to provide treatment for victims of child abuse and neglect, such as a child in need of care and protection and mandatory reporting. The core principles of this protocol are for the prevention, reporting, investigation, and management of child abuse in St. Kitts and Nevis. It brings all entities under one umbrella. This framework describes the role and responsibilities of different professionals, defines the steps that must be completed at each stage, defines the time frames for completion of each step, outline concrete and practical procedures for handling special issues that may arise, protects agencies from allegations of favoritism or politics in the handling of cases, inform the community of what they can expect to happen when alleged abuse is reported. It is designed to do all that is necessary and reasonable to protect children against harm and to prevent child abuse and neglect. The protocol is intended to give direction to the agencies and professionals involved in child abuse cases. The Child Welfare Board, the Department of Probation and Child Protection Services, St. Kitts and Nevis Police Force, Ministry of Education, Ministry of Health, and other non-government agencies. Child protection officers, teachers, principals, police, and medical doctors are the primary professionals who will be involved in the implementation of this protocol. In ensuring the protection of and support of children, a coordinated and integrated approach to child abuse investigation and management must be promoted. The mandates of each agency must be respected. Overlapping areas of activities among professionals must be acknowledged, and partnership must be expanded to more effectively meet the needs of children, families, and communities. The Child Abuse Protection Protocol is based on the following guiding principles. Suspected child abuse must be treated seriously and must be reported to the Department of Probation and Child Protection Services. When a child discloses abuse, particular care will be taken to ensure that the child has the support he or she needs upon making a disclosure. The disclosure of abuse by a child will be treated as a serious complaint and investigated with the same concerns as if the complaint had been made by an adult. An immediate response to allegation of child abuse must be provided. For the purposes of reporting or initiating a child abuse investigation, a child who indicates that he or she has been abused should be presumed to be telling the truth. The protocol is expected to achieve meaningful results in the following areas: to establish clear roles and responsibilities of agencies, to ensure child abuse and neglect cases are reported to competent agencies, where trained and professional personnel will ensure that all reports are investigated, prosecuted, and managed in a manner consistent with best practices. To develop and implement procedures to be used in receiving, investigating, prosecuting, and managing cases of child abuse and neglect and case of unexplained child fatalities. To develop and implement methods to be used in coordinating treatment programs for the perpetrator, the family, and the child. To ensure ongoing training of all personnel directly engaged in child protection, as well as technical and other support to agencies, organizations, and individuals whose efforts are directed towards abuse and neglect prevention. To ensure cooperation and information sharing between professionals involved in child protection and the coordination of all agency actions. To reduce emotional stress and provide ongoing protection and support to victims of abuse and neglect and their family. To enable the PCPS and law enforcement to cooperate and coordinate their investigative work. To accomplish the purpose and goal and objectives of the protocol, the Probation and Child Welfare Board will meet to ensure coordination and cooperation of various agencies, organizations, and individuals who are by duty or otherwise are involved in cases of abuse and neglect. Also, a multidisciplinary team or case conference meeting will be convened to ensure that there is collective input from persons involved with the child. They will provide assessment and consultation in abuse cases to help team members resolve difficult cases. They will promote coordination between agencies and identify service gap in coordination. Or communication between agencies or individuals. Also, enhancement of the professional skills and knowledge of individual team members will address by providing a forum for learning more about the strategies, resources, and approaches used by various disciplines. At a minimum, MDT meetings will have at least one representative from each of the following disciplines: law enforcement, prosecution, child protection services, medical, child health, and mental health. For sexual and physical abuse cases that are referred to and managed by the multidisciplinary team, the team MDT shall assist the provider to determine if there is a need for referral for treatment, further screening, or an extended evaluation. Identify the primary agencies which will make appropriate referral for services and assure follow-up of these services. Make arrangements for an appropriate agency to follow through where cases require an extended evaluation. The Probation and Child Welfare Board Act 1994 and Child Care and Adoption Act 2013 imposes the legal duty of mandatory reporting on certain categories of professionals to report cases and suspected child abuse. Mandated reporters include the police, teachers, and other school personnel, medical and nursing professionals, counselors, clergy, or any other person to whom a report of child abuse has been made. Mandated reporters who make reports in good faith shall be immune from civil and criminal liability, which may otherwise be incurred. A person making a report of suspected child abuse may request that his or her name is kept confidential. However, if the child abuse investigation results in a child protection hearing or a criminal proceeding, it may well be that the name of the person making the report can no longer be protected. Legal action may also be successfully taken against the person making the report if the person make it maliciously and without reasonable grounds. All reports of child abuse and suspected cases of child abuse and neglect shall be referred to PCPS by mandated reporters within 24 hours of initial report. An oral report may be made as soon as possible by telephone or otherwise, and followed by a report in writing within 24 hours to PCPS. If a report of child abuse is made to PCPS or is independently discovered by the agency has responsible cause to believe that such report is true. The agency shall immediately investigate the case. To complement the authorization of the protocol, the PCPWB, Probation and Child Welfare Board, has been able to secure funding from UNICEF and has retained Open Interactive, the company which designed e-government for the federal government, to design a cutting-edge case management system for probation and child protection services, and which will comprise a registry for cases of child abuse. The system will allow mandators to reporters to interact with each other in real time, and it will provide a repository of statistics and all important data pertaining to children from 0 to 18 years. It will link all agencies on a platform. It will also be a mechanism for all information relating to children in conflict with the law and several other matters. This system is expected to be rolled out to coincide with observation for Universal Children's Day in November. It is hoped that the protocol will be launched at the same time, as well as the completion of the UNCRC report. We share an understanding that child abuse is a multifaceted community problem, and no single agency has the necessary knowledge, skill, or resources to serve the needs of these children and their families. We must also ensure that children are not further victimized by intervention systems designed to protect them, and we must work together to prevent trauma to our children caused by multiple duplicative contacts with various professionals. I charge each and everyone here today to take this exercise as one that will impact our Federation for generations to come, that all organizations represented here today will play a vital role in ensuring that this protocol in its end state will accomplish its true intentions. We must recognize the need for flexibility, innovation as our agencies unite to develop a model service delivery to address the monumental task of investigation and treatment of child abuse and neglect, and jointly meet this challenge by sharing knowledge and resources to achieve one common goal of making these the best time to be a child. The ministry thanks all the stakeholders for your kind cooperation, and we look forward to you for your continued support. Thank you very much. you.